Okay, we're going on YouTube on Campus and Development Group versus Badillo, cause number DC207342. Counsel, do you want this on the court reporter's record as well, or what's your preference? I can't hear it.
Yes.
Okay, go ahead and make your announcements.
Reagan Herod here on behalf of Plaintiff Caps and Development Group.
Lawrence Granite here on behalf of defendants B&H Construction, Manuel Badillo, and 2BH Construction.
Mr. Peoples, we can't hear you if you're trying to talk. Still can't hear you. You're not muted. There's something wrong with your sound. We still can't hear you. Is Mr. Peoples on this case?
Yes.
We still can't hear you. Mr. Peoples, are you there?
Can you hear me now?
We can.
All right. Sorry about that.
That's okay. All right, let's go ahead and go forward. Movement, you may proceed.
Judge, I filed a reply to the motion that the clerk hasn't accepted yet. I'm sorry about that. I didn't know I was supposed to send it to the coordinator.
Okay.
I've made 3 objections to the declaration that was included in the response, and since it's a no evidence motion, these go straight to the heart of the matter. Should I email these to you, or should I just go ahead and argue it?
What is the other side's position on this? Are you guys okay with the late filing, or are you guys going to object to it, or what's y'all's position on this?
Oh, I'm prepared to argue. So I would prefer the court have it in front of it, but.
Then go ahead and email my court coordinator then. All right, let's proceed.
Okay. The objections that do you want to go ahead and argue the objections, Judge, or do you want to just argue the motion?
Just argue the motion, and you can incorporate in the objections if you need to.
Okay, yeah, well, they are our, since it's a no evidence motion, the only evidence they came up with was a statement from, that you have in front of you, I'm sure, from an expert. And he says in one of the statements he has is that CNC added 4 times the standard allowable amount of water to each of the 3 concrete loads. And the problem is that he's got no evidence that we added that. What he points to is some mixed tickets that were attached to the motion, and those are mixed tickets that are Big D documents. And there's nothing in there that indicates that CNC concrete pumping would have been the ones that added the water. And so he states in his declaration 3 separate times that CNC is the one that added the water, and that statement is simply conclusory, Judge. He's got no facts that he can point to that back that up. And the only fact that he points to is the big
I'm a little unclear why that would be conclusory. I mean, it's like, I guess I see it kind of like in a car wreck case. If you have the plaintiff saying it's red and the defendant saying it's green, it's not conclusory if the defendant provides an affidavit in response to summary judgment saying it's red or green. It's just what they believe the facts are. If they say that they believe that you guys, I guess, poured water in when you weren't supposed to, how is that? I guess I don't understand how that's conclusory.
He's got to have some basis for the belief, Judge. As an expert, he's got to point to some fact that leads to his opinion or his belief that we poured the water. And he simply doesn't state what that fact is. He wasn't present.
As an expert, I guess.
In the red light, green light situation, you have someone that's present. He wasn't present.
That's a good point. That's a good point.
And so the problem is, and Judge, this is a no evidence motion. And so I'm not going to go outside of the record, but so I'll just leave it at that he simply cannot say, he hasn't pointed to any deposition testimony that says, hey, listen, this is what this witness said as far as adding water is concerned. He simply points to the big, and I'll show you, if I could share, go ahead.
I'm sharing screen on I believe the correct affidavit. It says the mixed ticket shows signatures at the bottom left that states pump, acknowledge receipt of the concrete from Big D by pump operator. Let's see, the 3 mixed ticket regarding excess water added evidence that each of the 3 loads of concrete amounted to 10 cubic yards and 40 gallons of water were added at the customer's request. I mean, he's basing it on tickets, right?
And if you could go down to the tickets, Judge, you could see what I'm talking about. They're at the very end.
Exhibit 7, Your Honor.
Okay.
There they are, Judge. And you see, these are big D, and all it says at the bottom is pump. Somebody wrote in the word pump because we're the ones that received the concrete. That doesn't mean we're the ones that added the water. In fact, if you look at the part where it says water added, which is under the delivery times.
What exhibit number am I looking at here?
Exhibit 7.
Okay, and it says delivery times. Where does it say delivery time? Is that
at the top right?
Top right. Delivery time. Okay, I see. Leave plant 817. Arrive job. So where does it say?
It says water added at customer's request, just below return to plant time.
Oh, okay.
And see, what Big D's saying is that's the water that we added at the customer's request. And that's the thing that he's pointing to that says C&C added the water just because the word pump, you see in the bottom left where somebody's written in the word pump.
Okay.
We just don't think that's enough tied together. They needed to have somebody somewhere saying that C&C is the one that added the water. And without that, there's no evidence. That's the only evidence they point to. And with that, I'm finished.
All right, go ahead.
This is Larry Granite on behalf of defendant. First of all, Your Honor, I think on procedural grounds that this motion should be denied. We initially, some months ago, scheduled the deposition of a C&C Texas concrete pumping representative. That was quashed. We then moved into mediation phase. Mediation was held in May. It was not resolved. The case was not resolved, and Mr. Peebles agreed to produce his witnesses after mediation if necessary. So when it became necessary, I started requesting availability. We got no response, so we just noticed it. the deposition of a CNC representative is actually the field manager who was out there and can tell us what happened, as well as the corporate representative, is set for the 14th of next month, July 14th. Discovery deadline in this matter is July 30th, although we have a motion pending to continue trial and reset the dates. We also are going to need to identify the actual pump operator on the days that these 40 gallons were added to see what happened and who was requesting it and who was adding it. There's at least three elements involved. There's the concrete being delivered by the manufacturer, there's the pump truck, and then there's the contractor who's installing it. Either of them could have requested it, is our position. So based procedurally, we think that, we haven't even had an opportunity to question anyone from CNC Texas Concrete to see what happened out there. Second, if you look at those mixed tickets or delivery tickets from Big D, you will see that, actually, let's back up a second. First of all, we do state the standard of care in our declaration. Our expert does that. He says mixing 1 gallon of water to each cubic yard is appropriate. There are 10 cubic yards maximum in a delivery truck from the manufacturer. Adding 40 gallons is 4 times the amount. The expert also states that there's too much water added, and it's going to...
Mr. Granite, let me ask first, are you asking for a continuance of this hearing?
No, Your Honor, we're asking for a continuance of the trial. The hearing was already continued. However, because we didn't get the discovery that we thought we would have in time for it, but we have not had an opportunity to speak to anyone from CNC yet, and have very little in the way of material from them with respect to the discovery responses that could, indicate who or what was adding water. We need to talk to someone to see what actually happened on the ground.
So I guess I'm understanding, why aren't you moving for continuance if you still need discovery?
We already moved once for continuance, Your Honor, and we thought that opposing a no evidence motion for summary judgment, stating we haven't had an opportunity to get the evidence because the party we needed from has quashed our deposition notices and has not responded in time for us to get depositions, is the reason for us not having the evidence or even being able to develop.
But isn't the remedy, if you haven't gotten a chance to do discovery, a continuance, not a denial?
Yes, Your Honor. So
and I've already continued this once. Did you attempt to get the discovery in between the?
Oh yes, Your Honor. Yes.
And have you brought that to the court's attention? Has the court done anything about it?
We have not done it in a separate motion. We've done it. It's in our motion papers here.
I may be missing something here. So you don't want a continuance, but of the summary judgment motion, but you do feel that it's premature to hear it because you haven't been able to conduct all the discovery. I think there's a disconnect here. I'm not sure if I'm following exactly what your argument is.
Well, that's our argument on a procedural basis, Your Honor. On a substantive basis, we think that there is evidence to show that, at least create an issue of fact with respect to what our expert says in his declaration. And what that is if you look at Exhibit 7, you will see that the fine print on it says that by signing here, they're acknowledging that on behalf of the purchaser, they're receiving the concrete. The concrete is then the responsibility of the person who received it. And the fact that a pump is written down at the bottom indicates that it was received by the pump operator. The pump operator's receipt of it takes responsibility for that load of concrete. And by adding 40 gallons of water, as I already outlined, it violates the industry standards, and it does cause the defects that are being complained of. So we think that the two elements he's complained of in his motion, that being the breach of a standard of care, which we're showing here, 40 gallons is too much, and that the breach was the proximate cause, that being that the defects were caused by the too much water being added, is sufficient evidence to overcome the motion.
Response?
Yeah, I just don't think they get there with the evidence that they have. I mean, I've already argued that point. I don't know that I need to say anything else.
All right.
Your Honor, Big D also has a pending motion for summary judgment as well.
Okay, go ahead and make your argument.
Okay. So in addition, we're kind of similarly situated to CNC Concrete Pumping. We provided the concrete materials in issue. And in addition to what CNC has alleged, there's a lot of substantive issues on why the DO cannot pursue these claims against Big D Concrete. And so just big picture speaking, Capson is the owner of this project. They hired Big D directly to provide the concrete materials. They contracted separately with Badillo to install utilities and to pour and place the concrete. And so there is no contractual privity between Badillo and Big D Concrete. And because of that, the causes of action alleged by Badillo are improper and cannot be sustained. And so there's no amount of additional discovery that's going to change that. These causes of action are just not sustainable. And the causes of action are negligence, strict products liability, and breach of UCC and implied warranties. And our motion is not just a no evidence, it's no evidence and also traditional. And one of the main reasons why all of these causes of action fail is because of the economic loss rule. And the economic loss rule in Texas states that you cannot recover in tort when the damages are purely economic and it's a breach of a contract. And so in this case, that's all there was. Even if they are successful in proving that Big D's concrete materials are defective, which, you know, I understand there's probably a fact issue. I disagree with what their expert's saying, and I think we'll disprove him, but him stating that probably raises a fact issue over whether the concrete materials are defective or not. But even if that exists, the economic loss rule bars them from pursuing that claim against Big D because there's no contractual privity and it's purely economic loss. And so that bars claims for negligence, that bars claims for strict products liability, and that bars claims for breach of implied and express UCC warranties. And so that was our grounds under the traditional motion. In addition to those, though, under negligence, we allege that there is no duty here. The DO did not retain Big D Concrete. They cite very few cases to support a duty. In fact, they cite no cases that would show that there's a duty here. They do cite a case stating a general rule in a wrongful death case that the risk of foreseeability could create a duty, and they asked the court to see that there's a duty and create a duty here, but there is no law that states Big D owes a duty to Badillo. Had Badillo retained us, maybe there would be. And then also in strict liability, there's a little bit of a dispute, I think, between us on what the elements are in strict products liability, but the case law clearly shows that it's section 402A of the Texas torts, the restatement of torts, that applies. And it says one who sells any product in a defective condition, unreasonably dangerous to the user or consumer. And there is absolutely no proof that our concrete materials was unreasonably dangerous to the consumer. There's, the fact that our concrete may have had too much water added to it or didn't meet a strength test or something, that's not unreasonably dangerous, and that's not strict products liability just is not applicable in this case.
Well, I guess the question I have, and I'm not 100%, what is wrong with it? So is the concrete, did it have to be replaced? Did it have to be, what exactly happened to the concrete after, I guess, there was too much water in it?
So this is a residential development. These were for streets, and Badillo, he did the utility work, which all had to be replaced because it was installed incorrectly. In addition to that, the placing of the concrete, it was rough, it was uneven, it wasn't properly finished, and all the roads had to be ripped out as well. The city of DeSoto rejected it all. And so they had to all be replaced because of finishing. And so without proof that this is an unreasonably dangerous product, they can't pursue a strict products liability. I mean, that's just not, it's inapplicable. And then on the UCC and implied warranties, Badillo doesn't even address this in his response, so I think it should be granted on for that cause of action without a reply. But this UCC and implied warranty requires Badillo to have bought the materials from Big D, and he just didn't do that. So there's no evidence of that element, and that cause of action cannot be pursued. And then last, they have a theory of contribution against Big D. And while that's not really a cause of action, you cannot, a plaintiff in Texas cannot bring a claim for contribution unless they've also brought a claim for negligence and succeed on it. And so in this case, negligence is should be dismissed because there is no duty and the economic loss rule bars it. And so therefore there's no claim for contribution as well. So those are our grounds on the no evidence and traditional motions for summary judgment.
Mr. Granite?
Yes, thank you, Your Honor. I will start if you wanted to look at Exhibit 2 on attached to our experts' declaration. This goes to both the contract and the negligence causes of action, and we've actually already deposed Big D. Exhibit 2. We've already deposed Big D's corporate representative, and I'm not sure what his title was. He was someone in managerial duty out at the site. So if you look at this, what this is it's a Big D ready mix concrete submittal documents, and what these are documents that Big D creates showing the recipe basically for the concrete that's going to be used, that has to be used by our client and our subcontractors, as well as be approved by the township of DeSoto or the city of DeSoto. And there is no dispute in this case that the Big D was hired by Capson, by Keith Davis of Capson. However, if you look here, this is March 3rd, 2020 document showing that Big D was sending this document to our client, defendant 2BH, which is also Manuel Badillo and B&H Construction. So they obviously knew that B&H was going to be using this concrete. They knew on the next line down that it was for Parkerville Meadows. And so we think that firmly establishes the foreseeability that for the negligence cause of action, that my client was using this concrete. We also think that it is arguably makes them a third-party beneficiary of the contract between Capson and Big D. Therefore, we believe that both our negligence and contract causes of action are viable. The breach of duty element, there is clearly evidence of that. It's ample evidence of that the concrete that was used and brought to the site by Big D did not meet the specs, their own specs that were approved by the township. It was supposed to have something called a 4-inch slump, but it had a 6-inch slump, which means it's more watery. And then additional water was added to it, and that at the site. And that additional water is added for a number, at multiple parties, or could be multiple parties' requests. So we believe that the contract cause of action and the negligence cause of action are both viable causes of action. With respect to strict liability, we believe that it is a defective or unreasonably dangerous is the standard, not just unreasonably dangerous. And we believe, again, there's ample evidence that it was defective. With respect to the economic loss doctrine, well, first of all, we're in the process of subpoenaing the deposition of one of the companies in charge, hired by plaintiff after the fact, to replace what they're claiming were entirely defective underground utility installations. Now, these allegations of the utilities include allegations that the sewer inlets and the wings that were constructed with the use of Big D's concrete were defective. So we believe that the sewer inlets at least there's an issue of fact, because these are integral parts of the utilities that if the concrete.
Mr. Granite, let me ask you one question. Do you have any cases that support the position that a strict liability case can be brought in a situation where there's been no evidence that the product I guess product is the best way to put it. The product is not unreasonably dangerous.
We have cited a case that says just that it's defective or unreasonably dangerous, Your Honor. It's in our motion papers.
Let me see.
Please find it for you.
What page of your briefing is that?
A minute, Your Honor. Here we go. That would be page 10 to page 11 is where the quote is.
This is on negligence, it looks like. I know it's 10.
Yeah, it should be the top of page 11. Is that ours? Oh, do you have our amended? We filed an amended on the 21st of June.
So the 21st of June.
Yes, Your Honor. That's what my certificate says. That's the CNCs. It looked like. Yes, I think that's.
Is this it?
No, I think that I didn't catch the title, but I think this is our response to CNCs, our amended response to CNC. If you've paid. Yes, it is.
Is this the right document you want me to look at?
No, Your Honor. No, there should be another one.
Okay.
There it is, right above it.
All right,
There.
here.
Yes, Your Honor.
Okay. Right.
So there's our.
Your Honor, I'd like to just point out that case cited it's a wrongful death personal injury case. And while it does cite those elements, they go back to this McKisson versus Sells affiliates. And I do see in those elements where it is defective or unreasonably dangerous. But in 1997, the Supreme Court in American Tobacco versus Grinnell stated in Texas, Section 402A of the Restatement of Torts governs claims for strict liability in tort. Section 402A provides, element one who sells any product in a defective condition unreasonably dangerous to the user or consumer. This case was in 1997. It's after the one that they've cited. It's by the Supreme Court, and there is no or in those elements.
I would add, Your Honor, that this is a 2000. We pulled this out of a 2007 case, Ranger Conveying and Supply, citing back to a 1988 case.
So are you claiming a manufacturing defect?
Yes, Your Honor.
So I'm reading out of the pattern jury charge under PJC 71.3, and it says a manufacturing defect means that the product deviated in its construction or quality from its specifications or planned output in a manner that renders it unreasonably dangerous. An unreasonably dangerous product is one that is dangerous to an extent beyond that which would be contemplated by the ordinary user of the product, which the ordinary, with an ordinary knowledge common to the community as to the product's characteristics. So I do think he's right that's okay. Let me just go ahead and rule on this. I'm I'm going to deny the first summary judgment. On the second summary judgment, I'm going to grant it as to strict liability, denied as to negligence and contracts. So can you guys give me an order on all of that? One order that covers both motions. If you could send that, Mr. Granite, to opposing counsel so they have an opportunity to sign off on it, and then email it to my court coordinator. Make sure that on the order that it says that the hearing was held on June 28th, and preferably if you could get the other side to sign off and do it. That's the form. Anything else, guys?
Nothing. Thank you, Your Honor.
Anything else?
Judge.
Thank you, Judge.
All right, guys, you guys have a good day. All right, Zubarek versus Gonzalez. Are both sides here?
Plaintiff is here, Judge.
Okay.
Greg Fell for
Defendant.
what other defendants, Your Honor?
All right, let's
Caitlin
just,
Coker for other defendants. Mr. Milligan represents Ms. Henderson, and I think he's stuck in another hearing.
Mr. Welch, you want to go forward or pass your hearing?
Go forward, please.
Let's go on the record on cause number DC 1918220, Zubarek versus Gonzalez. Counsel, make your appearances.
David Welch on behalf of the plaintiff. Chuck Zubarek is also here, Judge.
Caitlin Coker on behalf of defendants, the First Amended Phillips Family Trust, Eric Sorensen, Jamie Sorensen, Dave Smeltzer, and Lindsay Smeltzer.
Greg Fell for defendants Francisco and Marianne Gonzalez.
Let's proceed.
Thank you, Judge. The matter before us today is the motion to reinstate the October interlocutory order in whole. Pretty fun fact pattern so far here, Judge. In October, you enter an interlocutory order that had some language about declarations and fences need to come down and things like that. There's a vote that was held in March. The vote passes at that time. After that hearing, you hold a hearing on May 7th, and you enter an order that vacates part of the October 23, 2021 or 2020 order, Judge. After that date, a recount is held under the property code that now makes that vote in March not pass. So what we're asking the court is, let's go back to how it was. The only thing that changed for you causing the vacate was that vote passing. Now that the vote's not passed, the October 23 order needs to be fully instated again.
Response?
Two things, Judge. First, we don't believe that this motion is properly before the court because Mr. Welch failed to comply with the requirements of Local Rule 2.07 and his failure to confer pursuant to that local rule makes it improper to have this hearing at this time. And I can go into that in detail, but I would also like to address the second, I would say most important detail that Mr. Welch didn't mention is that there is a redo vote to correct the recount decision, all of that. There's a redo vote happening on July 1st in just a few days. And we believe that the filing and setting of this motion now is premature. If this vote passes, which in all, from our perspective, we hope it will and expect it will, and I believe Mr. Zubarek knows it will, we'll just be back here revacating all of this in a few days. If it doesn't pass, then this is still premature because we should address it after we know what's going to happen instead of going through the same song and dance 3 times over. It's a waste of the court's time. It's a waste of attorney's fees. And at very least, this should be held under consideration until this redo vote is held, the votes are counted, and,
Mr.
everything.
Welch, I'm not concerned about the conference issue, but I am concerned about the redo vote.
Okay, yeah, Judge, certainly. 2 things. On the conference thing, I know the court said he's not that worried about it, but There's an email from Mr. Fell that's opposed. I can pull it up on the screen if you want to see it.
I'm not concerned about that. Can you address the other
Okay.
issue?
Yes, certainly, Judge. This is the exact argument that we made at the motion to vacate hearing where you did vacate part of the order. We said there's a recount vote, we're going to win the recount, and we need to hold off that. The court did not hold off. I'm asking the court to rule the same way now. Don't wait until for some unforeseen July 1 action. What we have, the facts before the court now are the vote did not pass. That October order needs to be fully reinstated. I mean, this is the exact argument that you did.
Yeah, it does seem to be
against
kind of the exact
today.
argument, Ms. Coker.
And I would submit that it's a very different scenario.
Okay.
Then we had the vote. We went through it. Mr. Zubarek found the technicality to appeal the will of the neighborhood, and we're back doing the same thing. Whether or not Mr. Zubarek would have appealed that vote was contingent. Didn't know what was going to happen, whether he was going to do it or not, whether the vote was going to be upheld, whether it wasn't. Very contingent outcomes on that. And with the facts before the court then, that made sense. Here it's very different because the vote has been noticed. It's been set. It's only in a few days. So the outcome is much more set in stone than this.
How are they doing the vote this time? Is it all going to be in person at a meeting, or are they going to mail it in, or how's it going to work exactly?
I believe there will be some absentee ballots, voting at the meeting, but I leave that, I won't represent anything that the HOA knows because I have no idea, but
Who's representing the HOA here?
We don't have anybody representing the HOA here because it was Mr. Zubarek's motion against the defendants. I don't know why the HOA didn't show up. But again, if Mr. Zubarek would choose to appeal that vote again, we don't know whether he will, whether he won, it's all up in the air. But we do know what is going to happen on the 1st. So I would say it's just very different.
Well, that raises serious concerns, Judge, that we know what's going to happen in a Democratic election. This is a little weird for counsel to be saying we know how the vote.
Did you mean you know what the outcome's going to be, or you know that there's going to be an election?
We know that there's going to be a vote. I don't know what the outcome's going to be. But I would say whether or not, whatever happens, instead of going through the song and dance 3 times over, I would admit that we should take this hold off for a few days to figure out what happens. And if at that point the vote doesn't pass and Mr. Zubarek's correct, we'll be happy to, address it then. But right now it's just a few days premature.
In all fairness, Judge, the only reason we're doing this quote unquote song and dance is because defendants would not wait for the recount to have the original order vacated.
And we didn't know whether or not there would ever be a recount.
Yeah, it was filed before the recount request was made. Judge, I'm not going to disagree with Mr. Welch procedurally, or even with the judge's comments on, isn't this kind of the same thing? Yeah, it is. There's no doubt about it is, but the vote's going to be in 3 days. And Ms. Coker is right. If you reinstate it, we're going to be right back here again. And if the court could just hold off and maybe let us report in a week, that seems to make a lot of judicial sense to me.
Do the absentee ballots have to come in by July 1st? How does that work?
Judge, I'm not involved in that. I can't speak to that. I'm sorry.
Is this going to be like our last presidential election where there was contests and, for the next 3 weeks? And isn't there some kind of, maybe we're calling this incorrectly, but isn't there some kind of special master or something that runs this, or isn't that why there was a recount? Or
well, there was an arbitrator that handled the recount. I'm sorry, Mr. Welch, go ahead.
I'm sorry, Judge. So I'll tell you right now, there's probably going to be a challenge depending on how the outcome comes because of the timing of the votes as is, and this has already come up in some depots and things like that. It's our contention that there's been early voting already, which isn't really allowed. So just so you know, Yeah, this is not a final shut July 1 type deal.
In order to appeal a vote, the person challenging the vote pays $5,000 to a neutral to do a recount. So my
Is that what
point is,
happened last time? They paid $5,000 to do a recount?
Yes.
Well, no, the HOA paid actually, because what you do is you file, we did jams, we agreed to Harlan Martin. Judge Martin has an hourly rate that says it's going to take me X amount of time, I think $400 an hour, whatever it is. The challenger has to prepay for the time. If the challenger wins and the outcome is different, then the HOA actually reimburses the challenger, which is what happened in this case. So the HOA actually paid $5,000 to hold a bad vote in March, is what happened.
which is fine, Judge. I can't speak to the HOA. All I can say is reasonably, I would assume that the HOA would have corrected the errors that Judge Harlan Martin pointed out. That's my hope, or I guess expectation. I don't know anything beyond that.
You know what? Let's just do this. Let's go ahead and reset this hearing to not this Friday, but the next Friday, and let's just see what happens with this vote. And I kind of agree with Mr. Fell here that we might as well just wait and kind of see what happens. And if it's still gray, I guess I'll have to make a decision then. But does that work for everyone's schedule?
The July 9 does not work for me, Judge, but could we get with the clerk or Rhonda and do an agreed date?
It works for me, Judge. I'll just be obedient.
Okay. That sounds good. So you guys just come up with a date, reach out to the clerks, and we can figure out a day for resetting this. I want to make it clear, I'm not denying it. I just want to have it reheard hopefully after the vote, and I wanted to do it as soon as possible. So just to make it clear.
Judge, just so you know,
we
do. I'm sorry, Judge. I didn't mean to cut you off.
No, go ahead.
We do have a hearing on July 12 on a compel, I think. Can we just tack it onto that probably?
Yeah, that sounds great. How does that sound to y'all?
That's fine, Judge.
Okay.
Thank you.
Rhonda for me. What time on July 12th does it set?
10:30.
Motion to reinstate is going to be, what'd you say, 10:30?
Yes, Your Honor. I show the motion to quash set at 10:30 on the 12th.
So we're going to reset this to the July 12th at 10:30. It's going to be at the same time as the other motion. All right, guys. Anything else?
Nothing for plaintiff. Thank you, Judge.
No, Your Honor. Thank you.
Judge.
All right. Thank you, guys. You guys have a good week, okay? And happy July 4th.
Thank you.
You too.
There's a Miss McMillan, I believe, on the line. Are you here for what hearing?
For the status conference at 11 in the Keeman versus Lewis case.
Oh,
I'm just here early.
that's fine. Mr. Whedon, what are you here for?
Your Honor, thank you very much. We were set for a scheduling conference hearing at 10 in 20-18306. We got an agreed scheduling order all worked out and got it to Rhonda this morning. And so we just wanted to make sure that
You're
okay.
not on the docket now, so that indicates to me you've got it. So is that McMillan? Ms. McMillan?
Yes, that was the same thing. I was just logging on to make sure we didn't need to do anything else.
Let me just double check that to make sure. Give me 1 second. I'll get the cause number. DC what?
20 18306. And I represent the intervenor, Leroy Hammond. I'm Frank Whedon.
Yeah, have them come on in. I'm almost done with my hearing, so just come on in. This is, I'm sorry. This is McEwen versus Lewis.
Correct, Your Honor.
Okay. All right, if you got the agreed motion, and it should be good, and we'll go from there.
Okay. Thank you very much, Your Honor.
All
Thank
right,
you,
you
Your
guys
Honor.
be safe.
Have a great
Thank
week.
you.
Bye-bye.
Hello, guys. How are you? So are these your new interns?
These are my.
You're becoming like Judge Hoffman. You have a whole group following behind you. So
Where's the rest of your?
I know. Well, they all finished on Friday, but we had a trial that actually we started jury trial, and so we have a trial that continued into this week, which I wasn't expecting, and so they're here watching the hearing docket, and then we have a very interesting informal jury trial or jury charge conference.
Okay.
It's a complicated fraud in a real estate transaction case. And there's a proposed 56-page charge. I won't go into the details.
Wow.
You may eventually hear this, but so we're trying to kind of narrow it down today. And then we have the rest of the trial. Good lawyers, very good lawyers on both sides. So if they want to come in, it's an in-person trial. So if they want to watch it tomorrow, I don't know what are y'all starting this week or?
This is their first day.
Their first day.
I would like to make a point to introduce them. Judge Martin Hoffman.
Yeah, nice to meet you guys. What are y'all's names?
I'm Haley.
Ryan Demers.
And where do you guys go to school?
I'm at Horizon 3L at
In
I'm Horizon 2LA.
And Horizon 2L at SMU.
SMU. So, and did you guys introduce yourselves?
I'm Casey. I'm Horizon 2L at SMU as well. This is our last day at Judge Hoffman. So.
And I'm Caleb. I'm also Horizon 2L at SMU.
But yeah, but they're welcome to come back they can watch. We have a hearing docket all day today, and then we have the pretrial, which will be in person the jury charge conference in person at 3, and then we have and then the trial finishes up tomorrow. So it's very hard to file an actual jury trial right now. So, but we're starting up our jury. Judge Moore just announced that we're starting up regular jury trial starting on July 19th. So I don't know how long they're interning. So there should be a lot more trials, I would guess, starting on July 19th. So
Wonderful. Thank you so much, Judge Hoffman. I'll let you continue your day.
Oh, yeah.
I would be grateful if, thank you so much for the invite.
Yeah.
To attend the 3 o'clock charge conference. I think I will take you up on that.
yeah, that'd be great. Let me chat with you real quick about Griffin. Is that his name?
Yeah, but it's okay. But yes, I'd be happy.
Let's chat real quick. Yeah.
This jury trial is actually really interesting. So it's fraud. It's like basically it's a landlord tenant kind of dispute with some fraud involved. So there was like a restaurant chain that had been in this one. Yeah, like a grocery store that had been in this one location for what? 10 to 20 years. And they were renegotiating another lease. And basically the landlord was like kind of going behind their back and like trying to sign another tenant into it, which is fine. Like you're allowed to get however much money you want for your thing. But he was telling them the whole time through that that they could still work on negotiating price after he had already signed a lease with their competitor, essentially. So they're suing for like lost profits, like $40 million in lost profits, and the fraud claim, which is like 7 to 9 million.
And then
There's a counterclaim.
Yeah, then there's a counterclaim from the defendant. Whenever the tenant moved out, apparently they trashed like the space. And
Not apparently.
Not apparently, we saw
They
it.
trashed.
It was pretty bad. It was trashed. Yeah, but that's only like $300 or $400,000 in damages. So
Only.
yeah, and
They're like,
interesting is like the landlord, it's like 2 parents and their son, and they're all like owners of the center, and so
And they don't speak
and they
English.
don't speak English.
Yeah.
And so it's been interesting. And the plaintiffs brought claims against both of the parents, the son, and the business. So it'll be interesting to see like who they end up.
Yeah, we think, or I don't know, you have a different opinion of it than I do. I think the plaintiff is gonna win. I think they're gonna win the fraud claim. Probably for like 6 million or so. I don't think they're gonna get any lost profits. But I do think that the defendant is gonna win on the counterclaim of the like destruct. I don't even know what the claim is for,
Yeah.
like the legal claim, but it's, I mean, they had photographic evidence and it was like very obvious that. But I think it's like obviously fraud and Gil doesn't.
I don't know. I mean, it's one of those where like it could just be like business is business, and like sometimes it sucks.
Well, they're allowed to find another tenant, but they specifically like kept lying to them, saying that they could like find a price that would work and all this while he had another lease. And they asked him like on the stand if like what he would have done if they would have come to a lease, like if he would have breached his lease with the other tenant, and he was like, yeah. So I mean, I think the jury was like, oh, okay.
Yeah. Well, we have a smart jury, like
Very
pretty
smart
educated
jury, yeah.
jury, so.
Like one guy owns like a $300 million business, and like another guy owns a business. They're all like very, smart.
What did y'all do for the first time?
I worked on pardon applications for spouse.
Oh,
cool. Is that your pro bono stuff or?
I worked at a nonprofit, like reviewing contracts with like health insurance providers.
Oh, cool.
I was at the Attorney General's office.
Oh,
that was interesting.
cool.
What do you guys got going on for that one?
Well, we both start new jobs tomorrow.
Yeah.
I'm gonna be at the Pettit firm, which will be Pettit, for the rest of the summer, and I'm also doing my pro bono through Legally, doing a driver's license restoration.
Yeah. I'm also doing that same driver's license restoration clinic, but I start at Burford Room tomorrow. I'm also Professor Carpenter too, so just, I don't know if you know him.
I don't.
Yeah, he's great. Yeah, he has common law and First Amendment and LGBT
Very cool.
classes. But do you guys know Guillermo Gomez? He goes to A&M. He's a rising too. Yeah, he was another intern with us. Actually, he might still be on the call. Yeah, he's great. But you might know, well, I don't think you know her yet, but there's another intern that goes to UNT right now who's trying to transfer to A&M. So her name's Alex Marlowe. You should keep an eye out for her. She's great. Yeah. So.
It's actually what were you in? Section 2.
Was one in and
You were there long.
Yeah.
Okay.
Yeah.
I mean, not like now.
Right.
I recognize her.
Yeah, she was.
Oh. Do you know any for Owen Farmer?
I do
You would
know.
think Section 2 was.
Yes.
Yeah.
You got it.
Yeah. He lived with someone in our section for like
Oh,
the
the Aussie, right?
Yeah.
Yeah.
Right.
He's very outspoken. Yeah.
Yeah.
Yeah, I remember the first time.
I don't know.
I was pretty close. I get close to be, I guess.
Yeah.
And going over to his house. It was an interesting setup there.
Yeah.
Yeah, there's a ton of cats.
Yeah.
I'm bored. Cats, I don't know.
Yeah.
So he moved over to his own. Yeah. What are you guys taking for?
I'm doing real estate transactions, tax, Con 2, B&E, and then international oil and gas negotiations. In the neighborhood.
I'm gonna drop a class if I explore you, but currently I'm in food and drug, constitutional criminal investigation, which I'm gonna drop if I get online video. Con 2 with Carpenter, BE with Crosby. Oh, international oil and gas.
I'm in regular oil and gas.
With you.
I think breastfeeding.
Yeah.
Securities regulations, creditors' rights. There's another one.
That you're gonna draw the video.
Yeah, I think it might be land use.
That's pretty stacked though. Seems kind of hard.
Yeah,
Lots of
I don't really
things.
know, you know. My sort of perspective on it is like everyone is going for like online too right now. Like I'd rather do it in the spring.
Yeah.
Or in the fall when I register for finals. Now I get my schedule.
Yeah.
Who did you have? I had Bloom on, if I had on for registration. Really? So do you want to take con? Yeah.
I wanted to do Conlaw like this semester because I didn't want to do great in between.
Yeah.
Two, I still feel like I'm kind of in the mindset of it, so.
For me, I was thinking like, I think they build off each other. I think they're pretty distinct in terms of all
Yeah.
structural.
Yeah.
You can definitely do it like separate.
I think that's why they just like summer that, like they have to finish.
Right.
You know, like a contract, one contract, two situations.
Yeah. I like contracts.
Who'd you have?
Rogers.
And that was great for me because
That's gonna be, that's all.
No, I just want
like I
I
felt so
heard
bad.
property. She's really nice.
Any visual learners, like forget about it.
Yeah.
You guys can see them? Okay. Yeah. She's nice. She's really nice. Exams, man.
Yeah.
She's like sort of stern.
That's exactly, yes. Yes. And then you have to like pull it in.
Are you guys, so like, if you don't get like your first full week, you just get on with your own? Okay. You're taking it no matter what?
Yeah.
And then any journal.
Any journal.
Is that the no journal?
Yeah.
Okay.
Should be in.
And two, if you say no, you don't really have to go back later and write back on. Like, I think if they offer it to you and you deny it,
I actually,
you're done.
going into it.
I mean, honestly, with the amount of people that apply or like wrote on, I mean, amount of people that take, I think most people will get on.
Yeah, I was gonna.
I mean, you might not get your first choice, but you'll get on.
Fair enough.
All right, thank you so much.
Thank you, guys. We'll see you back here at 3, and it'll be in person. We do require, for the trial tomorrow, we are requiring masks if you come to the trial. So just make sure you bring your mask with you because we have jurors here and we don't know their vaccination status and stuff. So, but the pre-trial, it's not as important because it's just the attorneys. So, but look forward to seeing you. Do you guys have any questions for me? Okay. All right.
After the.
I think pre-trial conference, I think jury charge conferences are one of the most interesting things you get to watch in the trial bench, especially if you want to do appellate work, because it's an area that gets appealed so often. And so watching how a trial judge watches it and then watching how the Court of Appeals deals with it, I think is a really interesting, should be interesting for you. So, this isn't a small little car wreck case. This is a fraud in a real estate transaction. It's a 68-page charge or whatever it is, 56-page charge. Yeah, so, and we're trying to narrow it down to more like a 20-page charge. So just going through that process, you can see how the sausage is made. She criticizes the sausage, but I'm going to show you how the sausage is made. All right. Yeah. What?
One final request, Judge Hoffman. I know you have like when Lisa Blue or other speakers.
Yeah.
Present, I'm gonna reach out to you and send you my email because I would love to have them in front of her whenever
she's already done her presentation this summer, but we have a huge thing coming in that you should try to go to. It's the DOL Trial Skills Boot Camp, which is on a Saturday in July. What is that, the 24th or the 25th? Whatever that Saturday is. And then I'm going to talk to the DOL about doing another, like the first half of the summer, we did the sister bars. I don't know if any of you guys went to that, but the sister bars meeting, Griffin did that. I can remember Griffin being there and it was very well attended, and we're going to do hopefully some type of seminar for all the interns. So I'll make sure. But if you didn't get that email, I'm worried I'm sending it to the wrong email address because I sent it to you last week.
I've got your coordinator's address. I've got your coordinator's address. I'll just ask her to confirm.
Okay.
That I've got you right.
Okay.
That way we can be in.
Perfect.
I don't want to just announce it to everyone.
I understand. Great to, great to see you. Are they, yeah, so they'll,
You're all fully vaccinated.
oh, perfect, perfect. So we're not allowed to ask, but it's good to know. So, so we'll see you guys back here at 3, okay? Great to see you guys.
Thank you so much.
No problem. Hello, Miss, we have both sides here, Mr. Kelly and Mr. Barrera.
Yes, Your Honor.
Oh, I left YouTube on. That's not great. Okay. Do y'all want a record for this hearing?
Yes, Your Honor.
Let's go on the record on cause number DC 197466, Chambers versus Methodist Hospitals of Dallas, DBA Methodist Dallas Medical Center. Counsel, make your appearances.
Sophia Bruera, counsel for plaintiff Linda Chambers.
And Michael Kelly, counsel for the defendant Methodist Hospitals of Dallas, DBA Methodist Dallas Medical Center.
All right, let's go ahead and proceed.
Okay, Judge, just brief summary. This is a slip and fall case where Ms. Chambers alleges she slipped on a wet floor in a patient room in the emergency room at Methodist Dallas. At the time, she was a visitor in the emergency room with several of her family members while her son-in-law was being treated in a different patient room. At the time of the incident, Ms. Chambers walked into the wrong room and slipped on the floor. We filed a no evidence motion for summary judgment on the premises liability claim, the negligence claim, and the gross negligence claim, as well as a traditional summary judgment on the negligence claim. Now, in response, plaintiff acknowledged and submitted no evidence on the gross negligence claim. In fact, in her response, she conceded dismissal of the gross negligence claim. So I would ask we at least get a summary judgment on disposing of the gross negligence claim. Turning to the negligence claim, I think the key focus for the court is going to be on the traditional summary judgment side. It's really a determination of whether this is premises liability versus a negligent activity. And as the court's well aware, when someone's injured on another's property, there's two causes of action: a negligence claim for negligent activity or a premises claim for an unreasonably dangerous condition. When the injury is the result of a condition on the property, the claim is only a premises liability claim. You cannot artfully plead to include a negligence claim when it only relates to a condition. Now, in her response, plaintiff cites to a Texas Supreme Court case, Austin v. Kroger, Texas, LP, to support her argument that she can have a claim for both premises and negligent activity. But that case is entirely distinguishable from our case. That was a suit by an employee against their employer, Kroger. The employee was injured mopping the restroom, and he was injured. And Kroger did not have a specific piece of cleaning equipment that they were supposed to have available to him. So his negligence claim was Kroger's failure to provide the employee with the necessary instrumentalities. The court in Austin v. Kroger held if only relationship between the plaintiff and Kroger were that of landowner invitee, the facts could only give rise to a premises liability claim, not a negligent.
Do I understand the facts correctly, though, that when this fall happened, that there was somebody actually mopping in the room when it occurred?
Well, and that is in dispute. So Ms. Chambers testified in her deposition that
So you're saying there's a fact issue about that?
Of whether or not the housekeeper was mopping at the time, yes. But there is not a fact issue in whether an activity, she wasn't tripped by the mop. She wasn't run into by the housekeeper pushing the mop or the janitor's cart. She, in her petition, clearly says, I slipped and fell on a wet substance on the floor. And she's got 3 allegations in her negligence cause of action, with the failure to maintain the floors in safe condition, failure to warn, and failure to timely clean up. All of those relate to the condition of the floor. So our argument in our traditional summary judgment is these don't relate to a negligent activity. It relates to whether or not the floor was wet and whether or not Methodist either made it safe or adequately warned Ms. Chambers. So it's our position that the negligence claim should be disposed of by traditional summary judgment because there just simply wasn't a contemporaneous negligent activity that injured Mrs. Chambers. The condition of the floor allegedly injured Ms. Chambers. Now, moving to the premises liability claim, which I think this case should focus on, we filed a no evidence motion for summary judgment. And as the court's well aware, the plaintiff has the burden of proof to respond to the challenged elements. And under the rules, 166 AC, any response or summary judgment evidence has to be filed and served at least 7 days before the hearing. Now, we filed an objection and motion to strike plaintiff summary judgment evidence on the grounds that it was not timely served. We didn't receive the response or any of the evidence until last Tuesday, middle of the day last Tuesday, when plaintiff's counsel emailed us a copy saying she realized the service didn't go through. Now, I'm not trying to pull a gotcha or any tricks. I'm just simply asserting objection under the rules that the evidence was not timely served, and there's no verified or sworn proof to show any good cause for late service to, or even a motion for leave to file and serve late summary judgment evidence. We also objected to select portions of the testimony and affidavit that plaintiff submitted with their response that was untimely served. I have to raise those objections or they'll be waived. But in the interest of the court's time, I'll plan on just addressing those objections when and if plaintiff cites to or refers to that specific evidence in response, or if the court prefers, I can go through them now.
No, let me hear the other side's response. Response?
Your Honor, which part do you want me to respond to, the entirety or?
Respond like you'd like to respond.
Okay, Your Honor, the first thing that I'll just kind of go in order of how opposing counsel has addressed it. So the first thing would be negligent activity. As Your Honor is aware, the law says that if there is a contemporaneous negligent activity that's occurring at the time that the plaintiff is injured, that qualifies as negligent activity. In this case, it's undisputed that one of Houston Methodist employees was mopping at the time. The negligent activity that took place was that when she was mopping, she did not have a wet floor sign in the area, in the vicinity that she was mopping. So that is what the negligent activity was that while she's mopping, and it's even in their own policies and procedures, both nurses testified that they need to have a wet floor sign to warn any visitors, to warn patients while they're mopping. And she was not doing that. So that was the negligent activity that was taking place, in addition to the fact that she was also mopping in the dark. So there was no way, even, the room itself was dark. There was no wet floor sign. So it would have been very, very difficult for Ms. Chambers to have even seen that there was someone in the room that was mopping. So that being said, that's our argument as far as negligent activity. And we do believe that that falls under the Austin v. Kroger case. And we also cited some additional cases, appellate cases for Your Honor to look at that specifically include mopping situations. That being said, I do want to address the untimeliness. While counsel says he's not playing a gotcha, it's very clear that this is a gotcha. We filed timely. We filed a proposed order timely. We filed the motion timely. The only issue that occurred is that for some reason, when my associate attorney was e-filing, the service of the actual motion for some reason didn't go through, but it was timely filed. The proposed order was timely filed and served. And as soon as we realized that for some reason it had not been served, we promptly served it as soon as we figured that out. But that being said, there was a lapse of only a few hours. So it wasn't that we've now served it, the day before the hearing or 3 days before the hearing. The reason that the rules are that you have to provide your evidence 7 days before is so that everyone can prepare for the hearing. The court can read the case law and the motions, and all of that's taken place. It was a mere couple of hours and overnight that this occurred. So I don't think that opposing counsel can provide any sort of substantive argument that this prejudices his client, that he was not able to prepare for this. Instead, he actually filed very, very lengthy briefing objecting to all of our evidence. So he did have sufficient time to go through all of that evidence. I would note that
the court is going to grant leave to if the response was late to allow the late response.
Okay, thank you, Your Honor. The other thing I would just like to point out regarding the evidence is it seems that every time that we obtained testimony that was favorable, there seems to be an objection to that testimony for reasons that I'm not quite certain of. Their own employees' testimony that were under their custody and control. So it seems odd that they use portions of that testimony in their own response and say that's valid. But then when we get testimony that's favorable to us, then they object and say it's an objectionable testimony. So I don't think that that's proper under the rules. We actually provided a response yesterday addressing specifically those objections and why we believe that they're improper. So that's what we would say with reference to the objections. If you will, I would like to just address the premises liability issue, which is what opposing counsel is saying is the main issue in this case. In essence, what opposing counsel is arguing is that our plaintiff, because she went into the room and it was not the room that her son-in-law was staying in, that she's either a licensee or a trespasser, and that she is not an invitee. What I would like to bring the court's attention to is there has been case law very similar to this, where either visitors are visiting a family member and they slip and fall in the garage, they slip and fall in the sidewalk, they slip and fall in the hospital. And in those cases, they've been found to be invitees. But even assuming that Your Honor finds she's not an invitee, but she's a licensee, the only difference between being an invitee and licensee is that as a licensee, we have to prove that they had actual knowledge that there was a danger. And in this case, that's absolutely satisfied because their own employee was mopping in the room, did not have a cone inside the room, and they knew that. So that employee's knowledge is imputed to Methodist. That is what the case law says. So either way, even if Your Honor were to find that she was a licensee, we still have sufficient fact issues for summary judgment to be denied. So for instance, the main fact issue contention in this case is whether or not Methodist adequately warned. And there's dispute and testimony regarding that. My client alleges that there was no wet floor sign outside the room, inside the room, and that the room was dark. Terry Gibbs, who was the supervising nurse, testified that she didn't see a wet floor sign outside the room or inside the room. Then we have testimony from another nurse who appeared at the scene who indicated that there was a wet floor sign that was placed outside the room, but there was nothing inside the room. So that in and of itself creates a fact issue because there's different testimony and the jury needs to decide whose testimony they're going to rely on. So we have provided evidence that they did not warn and they did not warn adequately. And the only other thing that I want to add is that both Terry Gibbs and the other nurse, Murad Salameh, they both testified that they have seen in other occasions that there are warning cones in the room when the employees are mopping. So it wasn't that it is a very unusual occurrence that they would place a cone in the room when mopping. They've both seen that before. They both know that the rules are that if you're mopping, you have to use a cone to warn patients and visitors. And Terry Gibbs, who was the supervising nurse, really hit the nail on the head when she said, the reason that we want to have these cones in the exact area where they're mopping is so that a patient knows or a visitor knows that, this room is being mopped and be careful where you walk. So in essence, summary judgment is just simply not proper here, except for the gross negligence claim, which we've already conceded. So we don't have an issue with the court granting summary judgment on that select claim.
Mr. Kelly?
Yes, Your Honor. I'll just respond briefly to counsel's negligent activity argument. And she even confirmed it herself that the activity they're complaining of was the failure to put a wet floor sign. That is part and parcel of the premises claim, the duty to warn of the condition. I disagree with the the characterization and the references to the Methodist testimony of our nurses, they both did not say there was no wet floor sign. Murad Salame, who was standing there caring for the son-in-law in the room next door, testified very clearly there was a wet floor sign right in the doorway. There was a janitor's cart and there was a trash can partially blocking the door. Now, I know that's going to be a fact issue, but I just want the court to be aware that the characterization that Methodist has testified that there was no wet floor sign is just simply untrue. And the reference to Terry Gibbs, she admitted she didn't see the fall. She wasn't even close to the area when the fall occurred. As the charge nurse of the ER, she responded after she was informed there was a fall. And at that time, the medical emergency response team had already cleared the room and was working on getting Miss Chambers up into a wheelchair or in the bed. So her testimony of whether or not there was a floor sign after the fall is not relevant to whether or not we adequately warned. Now, we do assert that Miss Chambers did become a trespasser, even if she was an invitee or a licensee. No invite or license to her, a visitor in the hospital, gives her express or implied permission to walk into another treatment room in the hospital. As a hospital visitor, her license was to be with her family member. But even just going through the licensee elements, plaintiff counsel talked about the evidence of Methodist actual knowledge of an unreasonably dangerous condition, and hypothetical knowledge or awareness of a potential problem is not sufficient to prove actual knowledge, which they have to show for a premises liability claim for a licensee. They also have to prove or have some evidence today that Ms. Chambers had no knowledge of the condition. And in her deposition testimony and in her affidavit, they have not pointed to clear, direct, positive testimony where Ms. Chambers has provided evidence that she didn't know of the condition. The only thing they point to is one sentence from her in response to my question of whether Methodist acted reckless or with conscious indifference. She just said, had she have had a sign there, I wouldn't have gone in there. That again goes back to the duty to warn. That is not clear and direct evidence that she had no knowledge of the condition. And just to respond to the comment that the case law is clear that hospital visitors are invitees instead of licensees, the cases plaintiffs cited are 2005 and earlier. In the last 10 to 15 years, Texas courts of appeals have been clear hospital visitors under these factual circumstances are licensees. 2005 El Paso and Wong v. Tenet Hospitals, 2019 in Amarillo, and 2020 in the Houston First District, all were visitors of a patient who fell or suffered an injury, and they were found to be licensees. The cases plaintiff cites to in her response, and she referred to today, they're very distinguishable. I mean, there's one where the wife of a husband sued the hospital after she was injured. She was staying continuously at the hospital. She shared payment of the fees for the medical expenses. She talked to the nurse and got permission to stay overnight. That rises to the level of invitee. Ms. Chambers was there with, I think, 7 or 8 other family members. There was no express or implied invitation. She was simply a hospital visitor, and we'd argue that makes her a licensee, for which plaintiff, in response to the summary judgment, has not provided sufficient evidence to dispute that she had no knowledge or clear and positive evidence of Methodist actual knowledge of the condition.
All right, thank you so much, guys. Let me just talk to you about one issue. So you guys are currently set for trial on July 20th. I don't know if you've already heard, but our local administrative district judge, Judge Moore, has announced that July 19th is when we're going back to regular jury trials. So we had been on this rotation system, and she has made the determination due to the COVID situation that we're able to do regular jury trials starting on July 19th. And so that puts it's kind of in an interesting situation for your case that you guys are set on the 20th. I'm actually calling juries, I think, on that 19th instead of the 20th. Anyway, I just wanted to get a feel for, are you guys ready to go to trial on this, or, you know, assuming I deny the summary judgment, what is y'all's situation?
So I think, at least for plaintiff side, there's still a couple more depositions that we would want to take. So for instance, the treating physician. So for instance, in this case, she broke her femur. So we would want to take the deposition of the treating doctor, who's actually ended up being treated at Methodist. So it would be a Methodist doctor. And I'm sure that, you know, opposing counsel may be able to assist with, you know, getting that scheduled, just to sort of explain what her injuries were. So that would be a deposition that we would want to take. The only other thing was, when I originally took those depositions of the nurses, they had indicated that the cleaning staff had specific policies and procedures that they believed. Opposing counsels indicated to me that that's not correct. I would want to at least take the deposition of someone in maintenance to just make sure that that's actually accurate, that there are no policies or procedures that would come into play in this case about, you know, like a handbook or something like that. So those would be the only two depositions I believe that I would need ahead. So I don't know that we would be ready on the 20th.
Kelly? And we don't have to decide this issue. If you are opposed, I'm not going to move the trial setting. But if you're both in agreement, I'm happy to move the trial setting.
I'm not in agreement that we need to move. I think it's ready for trial. I think it's bizarre to think that we're finally getting to the point where we're going back to the courthouse. I'm excited, but plaintiff's counsel's mentioning, I do want to respond to that even though the surgeon performed surgery and treated her at Methodist, that does not make her a Methodist physician. I have no control over an orthopedic surgeon at Methodist. They're independent physicians. They're not employed by Methodist. So plaintiff would have to subpoena that surgeon for deposition if they don't get her or him to voluntarily agree to show up. And my only response to that is we had a docket call in March, and plaintiff's counsel mentioned there's a couple more depositions that need to be taken. I think we did 2 of those nurses. And she also mentioned that the treating physicians needed to be deposed. Well, there's been no mention to me that the treating physicians still need to be deposed until right now. So I would just argue that I think this case has been on file long enough that plaintiffs hadn't.
Have y'all been to mediation on this?
We went to a half-day mediation, and it was aborted about halfway through because plaintiff decided they needed to take some depositions, which we volunteered and put up 2 of our nurses.
Okay. I'm not ruling on the continuance either way. If it was agreed to, I'd be glad to move it. But if it's not agreed to, then we're going to keep it on that day, and you guys can file a continuance and fight it out in the proper course. I want to let you know it's going to be set on the 19th, not the 20th. I'll go ahead and just deny the summary judgment now, except for as the gross negligence. So I'll grant it as to that. Do you want to go ahead and submit an order on that, Ms. Barrera?
Yes, Your Honor. I believe there should be one, but I will double check and make sure.
Well, it should have. Does it have me denying or granting it as to gross negligence?
I understand. I'll have to look. It may not. So I'll go ahead and I'll draft one and then send it to Mr. Kelly to make sure it looks good so we can.
And so just let me tell you how we do this now with COVID is that we are with remote, really not so much COVID, is if you could go ahead and share it with Mr. Kelly, see if you can get an agreed form. If not, either way, when you submit it, make sure it says on it, you email it to Rhonda and e-file it. And on the order, instead of on this day, put on June 28th, 2021, the court made the following ruling, or however you want to put it, but put the date of the hearing on there. It makes it easier for me to be able to find the hearings and rule on them. All right. Anything else, guys?
Briefly, I don't have client approval to agree to the continuance. I'll talk to them, Ms. Barrera, and I'll let you know what they say. If you can let me know kind of who you're looking for, what depositions, what discovery you need, and I'll have that discussion with them, and maybe we can reach some agreement to push it to the fall or just.
Is it possible that you guys would go back to mediation on this? it seems like this might be one that would be good to go back to mediation on.
I think we could. I don't think my client would be opposed to that. I mean, we were at mediation. We were ready. We had our evaluation. And I think we've done some more discovery. We know their position and they know ours. It might be right for trying to finish up me. I mean, I think we paid for a half day and we still have a couple hours left with Mr. Gilbert. So I think we could try.
Yeah, I don't have a problem with that.
Sounds good. All right. Well, just get me an order and let me know what you guys decide about the trial setting. If you want to submit an agreed continuance, that would be fine. But if you can't, then you'll need to file a opposed continuance and get it set for hearing.
Okay, thank you, Your Honor.
All right, guys.